On September 21st, IT major Wipro fired 300 of its employees after finding out that they were moonlighting by working parallelly with one of its competitors. Wipro chairman Risat Premji has called moonlighting as a complete violation of integrity in its deepest form. On the other hand, back on August 3rd, food tech startup Swiggy announced an industry-first moonlighting policy by allowing its full-time employees to take up side gigs outside of the hours under certain conditions. Similarly, Union Minister of State for Electronics and Information Technology and Skill Development, Rajiv Chandrasekhar, on September 23rd, supported moonlighting, saying that companies should not put a lid on employees' dreams. So what exactly does moonlighting mean? What is this trend exactly all about? And importantly, are there legal repercussions to moonlighting? We will find out answers to all these questions in this video. But before that, please remember to like and subscribe to our YouTube channel so that you can keep getting updates on all our videos. So moonlighting essentially refers to the practice of holding more than one job outside the normal working hours without the knowledge of the principal employer. An employee may work a normal 9-to-5 job as a primary source of income but work nights at a different job to earn some extra money. This is generally done to have another source of income or to even make better utilization of one's talent and passion. However, the problem arises when you're working under two formal legal contracts and working for your rival company as well. Moonlighting is not completely prohibited under the law in India. However, the Shops and Establishment Act of various states as well as the Factories Act of 1948 prohibits double employment. However, each state has its own Shop and Establishments Act prescribing rules which may change from state to state, and in some states, in fact, IT companies are exempt from the law. Certain employment contracts can also contain covenants restraining employees from working in dual employment as well as confidentiality clauses. Apart from wanting employees' concentration completely on companies' work, one of the crucial reasons why organizations bar moonlighting is because they do not want employees joining competitors and soliciting other employees, clients, as well as disclosing their trade secrets. Section 60 of the Factories Act of 1948 prohibits double employment of adult workers in factories. As per Section 2, subsection S of the Industrial Disputes Act of 1947, or Section 2, subsection ZR of the Industrial Relations Code of 2020, the definition of worker means any person employed in any industry to work for a reward, whether the terms of the employment may be expressed or implied. Section 65 of the Bombay Shops and Establishment Act of 1948 also prohibits double employment by stipulating that neither the employee will work nor any employer will permit the employee to work in any establishment when the employee is on leave or given a holiday. Similarly, Section 9 of the Delhi Shops and Establishment Act of 1954 states that no person shall work at the business of an establishment or two or more establishments or an establishment and a factory above the period during which he may be lawfully employed. Not just according to statutory provisions, even as per certain judgments of the Supreme Court, negative covenant of not joining a competitor to an extent is enforceable during the operative term of a contract. In fact, if a contract expects an employee to work for a required number of years but he exits prior to the stipulated period, he can be stopped from joining the competitor till the end of the stipulated period. For instance, the Calcutta High Court recently, in the case of Dr. Sudipta Banerjee versus L.S. Dawar and Company and others, upheld an injunction order passed against former employees of a law firm, restraining them from divulging confidential information and trade secrets gathered during the course of their employment. For instance, the Calcutta High Court recently in the case of Dr. Sudipta Banerjee versus L.S. Davar and Company and others upheld an injunction order passed against former employees of a law firm restraining them from divulging confidential information and trade secrets gathered during the course of their employment. Pertinently, the High Court had opined that sharing of such information and communication would not only be unethical but would also constitute a breach of the confidentiality clause in the service contract, causing serious prejudice to the law firm. While there are statutory provisions, it is always advisable to include specifications of not working for another employer in the appointment agreement. Employment contracts must also contain restrictive covenants such as non-compete, non-poaching and non-disclosure clauses, or even a moonlighting clause in order to protect the company's interests. Employees who wish to pursue dual employment can do so with the knowledge of the employer by agreeing to employment contracts accordingly framed to protect their interests, which allows them to operate part-time for various employers without violating confidentiality and other such restrictions. Thank you. I'm Muratrika Bhaumik for LiveLaw. Let us know in the comments below what you think of moonlighting.